Welcome to this explainer on Padilla versus Velasco. Decided by the Supreme Court in 2009, this case is pretty much the ultimate cautionary tale in property law. It really tests the boundaries of land disputes, the raw power of prior possession, and exactly what happens when your paper title doesn't match the dirt you're standing on.
Picture this absolute legal and practical nightmare. You buy foreclosed land from a bank, secure the deed, build your dream house, and even start harvesting the coconuts. Then, years later, someone knocks on your door and calmly tells you that you are living on their property. How does the law even begin to untangle a mess like that?
Today, we're going to unpack the initial property dispute, break down Unlawful Detainer versus Accion Publiciana, look at the crucial rule of prior possession, discuss collateral attacks and time limits, and finally, reveal how the Supreme Court ruled.
Let's jump right into part 1, the property dispute, and see exactly how this whole situation kicked off. This timeline is literally a perfect storm of confusion. So, in 1944, Dr. Artemio Velasco buys a parcel of land in Pagsanjan, Laguna. Fast forward decades later to 1980, and a rural bank forecloses on a piece of land owned by a completely different Velasco relative, a guy named Valeriano. Then, in 1987, the Padilla family buys that foreclosed land through a trustee arrangement with the bank. They move in, put up a fence, and build a house. 4 years later, in 1991, the heirs of the original 1944 buyer, Artemio Velasco, file a lawsuit against the Padillas, demanding they pack up and leave.
During the trial, a geodetic engineer drops an absolute bombshell. These were two completely different properties. The Velascos owned Lot 2161, which was about 7,800 square meters. The Padillas had legally purchased Lot 76 Part 2 from the bank, which was 10,000 square meters. The tragic mistake here? The Padillas bought Lot 76 Part 2 on paper, but mistakenly built their actual lives on the Velascos' Lot 2161 because they trusted a bank representative's word over a proper boundary check.
Moving on to part 2, Unlawful Detainer versus Accion Publiciana, and choosing the right legal weapon.
So, the Velascos filed for what's called an Accion Publiciana. In plain English, rather than fighting a definitive battle over the ownership title, this is a plenary action in the regional trial court that isolates one very specific question. Between these two parties, who has the better right to possess this property right now? It operates completely independently of who ultimately holds the formal title.
Now, the timing of the lawsuit is absolutely everything here, and it's a massive distinction you have to understand. If you get kicked off your land and you sue within 1 year, you file an unlawful detainer or forcible entry suit under Rule 70. It's summary, it's fast-tracked. But if that 1-year window closes, your remedy elevates to Accion Publiciana, which is a regular, full-blown trial. Since the Velascos were dispossessed in '87 when the Padillas moved in, but didn't actually sue until '91, Accion Publiciana was exactly the right vehicle to use.
Let's look at part 3, the power of prior possession. The Supreme Court makes a crystal clear point here that is the absolute cornerstone of these disputes. In Accion Publiciana, the main event is always possession. Ownership is strictly secondary or ancillary. The court only looks at title documents if they absolutely have to, just to figure out the timeline of occupancy. Resolving who had physical boots on the ground first is the entire ballgame. And the Velascos masterfully proved this. They basically brought the receipts. They traced Artemio's original 1944 purchase, showed that his brother kept administering the land through a hired caretaker after Artemio died in '49, and stacked up a mountain of original tax declarations and receipts in Artemio's name. They established a rock-solid footprint on the land decades before the Padillas ever showed up in 1987.
Which brings us to part 4, collateral attacks and time limits.
Naturally, the Padillas didn't just roll over. They argued the Velascos waited way too long to file the suit. But under Article 555, Paragraph 4 of the Civil Code, the real right of possession isn't lost until 10 full years have lapsed. The court did the simple math. The Padillas entered the land in '87 and the Velascos sued in '91. That's only a 4-year gap. The Velascos were well within the legal time frame.
The Padillas also tried to argue that the foreclosed bank lot and the Velasco lot were actually the exact same piece of land, but the court shut that down immediately, calling it an illegal collateral attack. You simply cannot try to invalidate someone's registered land title indirectly during a dispute over possession. If the Padillas truly believe the titles overlapped, the law requires a completely separate, direct legal action. You cannot hijack an Accion Publiciana case to cancel someone's title.
Finally, Part 5, the Supreme Court ruling, and how this all shook out.
It was an absolute clean sweep for the Velascos. Because they overwhelmingly proved prior possession, the court ordered the Padillas to pack up, vacate immediately, and restore the land to the Velasco heirs. But it didn't stop there. The Padillas had to render a strict accounting of all the crop proceeds they've been harvesting since 1987 and pay them back. And honestly, the most devastating part, they were ordered to dismantle their house and all their structures entirely on their own dime. It's a brutal reality check of what happens when you build on the wrong soil.
In one final desperate Hail Mary, the Padillas begged for a new trial because their previous lawyer had been seriously ill and mispresenting some evidence. The court wasn't buying it. They basically stated that a lawyer's illness or negligence doesn't erase 40 years of historical fact. The Velasco's prior possession was already overwhelmingly set in stone.
This explainer leaves us with a really stark warning. In real estate, acting in good faith and holding a piece of paper from a bank just isn't enough to save you if you are standing on the wrong coordinates. It begs a larger, more provocative question for our property systems. When the Torrens system promises absolute security of title, who should really bear the ultimate burden when the physical reality on the ground completely contradicts the paperwork in the vault?